Hi, this is Stephanie Troncoso, and I will be presenting the case Garrett F. versus Cedar Rapids Community School District for you today. I will not be covering each slide word for word, as I will not have time to cover everything, but I will provide you with the most crucial information, and then you can also visit the slideshow if you want more details. For the background, Garrett is a 12-year-old boy who lives in the district with his mother and his brother. He visits his father every other weekend. He has attended the school since kindergarten, and at the beginning of this study, he was in the 6th grade. He is a friendly, creative, above average in ability student and is successful in school. He receives no specially designed instruction. When he was 4, he was injured in a motorcycle accident and sustained an injury to his spinal column, which resulted in paralysis from the neck down. He's wheelchair bound and relies on a ventilator for breathing. Garrett does have complete head movement, can speak, and controls his motorized wheelchair with a puff and suck straw. Garrett requires a responsible person around to take care of his personal needs. He needs catheterized once a day, suctioning of his trach as needed, assistance with food and drink, getting into a reclining position for 5 minutes each hour, that should say, and ambu bagging occasionally when his ventilator is malfunctioning or needs checked. There's also a possibility that he would experience autonomic hyperreflexia, typically in reaction to a full bladder, and so he does need someone who can perform emergency procedures nearby. This has never occurred at school and has not occurred at all for Garrett in recent years. He came to school, back to school in 1989 after his accident, and his mother's younger sister, who was 18 at the time, took care of him at school for the first year. This healthcare at school was paid for by his father's insurance, and at some point the maximum payment limit was reached, so that coverage ceased. Then his mother found another insurance program through a special program where she paid $1,183 a year. The coverage has an annual limit, which is usually reached just before school starts in August each year. And healthcare for the remainder of each year is paid for from a trust fund that was established for Garrett. At home, he's taken care of by family and friends, except during nighttime hours when a nurse cares for him so the family can sleep. Garrett's mother said that she would have hired a non-licensed caregiver for that, but the insurance company wouldn't pay for that type of care, and it was impractical for her not to maintain consistent care year-round. His doctor indicated that a healthcare provider or nurse's aide could adequately care for Garrett, and it does not require a licensed nurse at this time. Since first grade, Garrett has had a full-time teacher associate helping him in the classroom. He's also had access to a computer and also received transportation, occupational therapy, and was in the school's extended learning program. He is in the regular PE program at school. The story began when the mother sought a due process hearing when the district refused to provide health care during the school day. She claimed that she had first asked for payment for these services when Garrett returned to school following his accident. She stated that she had brought it up several times since then, the latest time in March of 1993. She did not hear back. She kind of went back and forth with the district director of special services. They were asking for more information, detailed information regarding his medical needs. When she finally responded to that request, her and the doctor answered a number of questions. And again, the doctor reiterated what Garrett's needs were and mentioned that the only emergency situations foreseen would be a problem with the ventilator, an airway obstruction, or a respiratory infection. It was also stated that his ventilation could be supported temporarily if the ventilator needed servicing. At that point, a meeting was scheduled between Garrett's mother and the district staff to discuss these needs and develop a plan for Garrett. They then held an IEP/IHP meeting. IHP stands for Individualized Health Plan, and the IEP was developed but only for services of occupational therapy, 60 minutes per semester. The IHP was developed at the same meeting by the district's nursing staff and Garrett's mother. At the end of that meeting, The district staff concluded orally that the items in the IHP were medical services rather than healthcare services, and thus were not the responsibility of the district to provide, because they required continuous monitoring and assessment, highly technical and extensive nature of care. Following that meeting, Garrett's mother disagreed with those decisions and wrote a letter outlining why she disagreed with those decisions. Those reasons are listed here, but basically she felt that Garrett was capable of verbally advising someone of his needs, that he had had a good placement in the classroom, and that inadequate attention was given to the doctor's recommendations about what was needed. In response to her letter, the Executive Director of Special Education from the AEA conducted an investigation of the situation. The district's position was then that the services Garrett needs are beyond the legal requirements and definition of related services due to their continuous nature and their need to be provided by a licensed provider. They also stated cost as a reason and indicated that a homebound program would likely be the alternative for Garrett without an external funding source. The district also argued that because Garrett didn't need specialized instruction, that he was not entitled to any related services. It was determined then that the district was willing to consider hiring a non-licensed health caregiver for Garrett while he was at school, but they were concerned that there was a conflict with the standards of the State Board of Nursing. It was also considered that Garrett's current teacher assistant and a healthcare provider may not both be necessary, as the duties of the TA could be assigned to the healthcare provider. The Iowa Board of Nursing at that time failed to provide specific criteria regarding who should be doing these nursing duties, if it should be an RN or if an RN could delegate the duties to a non-licensed person using his or her best judgment. In May of 1994, then, the district filed a petition for a declaratory ruling from the Board of Nursing. It outlined Garrett's needs and asked whether they could be delegated by a school-employed RN to a non-licensed person. The response said, within the scope of the practice of nursing and require the knowledge and skills attributed to nurses, basically meaning that the Board of Nursing declared that Garrett's care should be provided by a nurse and not a non-licensed person. The district does provide healthcare services for other students, and very similar services, in fact, to those that Garrett needed. The primary difference being that Garrett needed the ventilator for life support. It was found by the district that students in Garrett's situation were getting care all the way from a non-licensed person all the way up to an RN, and so the range was great. The district's manager of health services testified that it was her opinion that Garrett's care at school should be provided by an RN. And if not provided by an RN, there should be an RN on site to supervise the care. The bottom line on the cost situation is that several calculations were provided in the case study representing different scenarios for the district and how they would affect the budget, but the bottom line was that it wouldn't cost much comparatively to what is spent on other students for the district to provide Garrett with the nursing services, regardless of if they chose a non-licensed caregiver or a licensed nurse. In the rebuttal, Garrett's doctor disagreed with the IHP conclusion that Garrett's required constant healthcare supervision, monitoring, and assessment. Garrett's father testified that he visits him every other weekend without healthcare services, and Garrett's mother reiterated that she did not agree that a licensed nurse was required to care for Garrett. Some applicable laws here, I provided them for you, but I'm not going to read them verbatim. Basically, the one that came up a lot was the 41.114 to A through B, to the maximum extent appropriate, children with disabilities, including children in public or private institutions, are educated with children who are non-disabled, and basically they should not be separated only if the nature or severity of the disability is such that education in regular classes with aids and services cannot be achieved. And the administrative law judge cited a couple other cases here, the Tatro case being one of them. This was also in our text. But basically this case ended up making the bright line rule that if the services needed must be provided by a physician, then they would be excluded from related services. But if the services needed could be provided by a nurse or a non-licensed caregiver, then they should be considered a related service and must be provided. The administrative law judge also cited this case here. You can read that through at your leisure. And some other applicable laws here, the definition of related services, definition of medical services, and school health services and school nurse services. And again, that last one, same thing, only if it cannot be achieved satisfactorily in the regular education classroom should students be removed. So the administrative court decision stated that Garrett basically must be provided this nursing care at school by the district as a part of his free and appropriate public education. There is no limitation on cost or special training. The administrative law judge has no authority to determine who is qualified to Garrett. That decision remains with the Board of Nursing. However, it does not resolve the district's responsibility to provide these services. And some textbook references, again, the Tatro case provided that bright line rule, but subsequent lower court rulings muddled the issue by not abiding to this rule and made some decisions based on the complexity and the cost of care. In Garrett's case, the majority of 7 justices ruled again that the appropriate distinction on required health services should be whether they require the attention of a licensed physician or not. And nursing services are required regardless of the cost or complexity in order to ensure FAPE and LRE. The district appealed this decision, and the case moved on to the U.S. District Court. The administrative law judge's decision was upheld. The district appealed again, and the case moved on to the U.S. Court of Appeals. Again, the decision was upheld. And one last time, the district appealed the court's decision, and Garrett's case was taken all the way to the Supreme Court and was decided on March 3rd, 1999. The Supreme Court agreed with the lower courts, finding that the district was obligated to provide Garrett's healthcare services. They rejected the district's assertion that the continuous nature of Garrett's services make them medical services, and the Supreme Court rejected the district's claim that providing Garrett services would result in an undue financial burden. They went on to state that if they adopted a cost-based standard, it would be engaging in inappropriate judicial rulemaking. Personal responses: I agree that Garrett's healthcare costs should be paid by the district. Again, I'm not sure that the healthcare services should be paid with education dollars, but that fact is beyond the scope of this case. With the law as it is written, the verdict is appropriate. Seems obvious that the LRE for Garrett is definitely not at home. I also agree that the issue of who provides Garrett's care should not determine whether or not it's paid by the school. That would be up to the Board of Nursing to decide who is qualified, but the school needs to provide the care. In support of the school, I understand their caution in hiring a non-licensed caregiver for Garrett. If they're paying the bill, they should have the liberty to ensure that the care provided isn't going to land them another court date. Some implications here for you. Related services personnel are not required to attend IEP meetings, but their input is invaluable, so it should be documented and addressed at the meetings. And it's important to note that the complexity and cost of accommodating a student in the LRE should not be a reason for removing the student from the placement. Here are the questions for you to answer. The administrative law judge indicated that he doesn't agree with spending education dollars on healthcare services. Do you agree or disagree, and why? And the bright line test. Do you have another idea for how this could be determined, or do you agree with this definition? And number 3, should all related services personnel be required to attend IEP meetings? Thanks.